Introduction. The period after the revolution was one of great instability and confusion. In fact, there were divisions among Americans about whether their representatives were legitimate enough to negotiate. Moreover, there were a group of people called loyalists who wanted to maintain their relationship with the monarchy, and others who wanted complete separation. So it would be misleading to say war waging was an inevitable or unanimous decision, since there were different views not only in the Congress but between the masses as well. Notably, in the Second Continental Congress, two of the main most pressing issues the delegates had to deal with were finding a legitimate frame to represent all the states and to decide on what political nation they would form. Thus, they all agreed on the need of a constitution that would preserve the 13 colonies' best interests, which include a common fundamental law that could protect states and people. But how? After signing the Peace of Paris, which ended the Revolutionary War, the issue of the representatives was still there, so the Congress had to legalize its statute. This is when the Articles of Confederation came into being in 1777 as a permanent confederation. The articles were considered to be a failure since they had little power to enforce its resolutions or to change anything at all. That's how the Constitutional Convention was held in 1787 to reconsider revising the articles in hopes of coming up with a stabilized constitution that would meet up the expectation of the entirety of states. After more than a decade of heated debate, a common document was ratified with a set of rules to ensure the benefits of all parts. Hence, it should be mentioned that there were some events in history that helped to determine the shape of the Constitution and accelerate the process of writing it up, such as Shays' Rebellion, for it proved the ineffectiveness of the Articles of Confederation in dealing with internal orders, and Northwest Ordinance, for it outlined the process of adding a new state to the Union and guaranteed that they would be equal with the rest of the 13 colonies. The document also protected civil liberties and outlawed slavery in these territories. At the time, there was dispute over how much power should the government obtain, which led to a chasm between those who wanted a strong central government, namely the Federalists, and those under the label of anti-Federalists who wanted a national government with limited powers so that the states' rights were guaranteed. Later on, the conflict dissolved when both parts involved found a common ground, specifically amendments promised by the Federalists to protect individual liberties such as freedom of religion, press, and speech, designed as the Bill of Rights. Upon these adjustments, the Constitution was ratified between 1787 and 1789 and was put into effect in 1789. The purpose was to create a federal government and to delineate its powers. In a way, any power not blatantly stated in the Constitution are left to the individual states to decide on. The Bill of Rights was indeed adopted in 1791 after the election of George Washington as the first President of the United States under the Constitution. Historians agree that the Founding Fathers allowed opinions to be voiced by adding the amendments that would secure liberties to both individuals and states.
After the American Revolution, the newly formed United States of America faced the challenge of creating a federal government that could unify the 13 states and ensure their survival. In 1787, a constitutional convention was held in Philadelphia to draft a new constitution for the United States. The resulting document established a federal system of government with a strong central government that had the power to tax, regulate commerce, and maintain a standing army. The Constitution grants the federal government the power to make treaties and manage immigration, and it establishes the federal government as the supreme law of the land. The federal government of the United States during this time was still shaping itself, and the framework for nowadays government was being created. The federal government was structured around three branches: the executive branch, the legislative branch, and the judicial branch. The president is the head of the executive branch and has the power to veto legislation passed by Congress. However, Congress has the power to override the presidential veto with a 2/3 majority vote in both the House of Representatives and the Senate. Legislative branch. Congress has the power to make laws, but the president has the power to veto those laws. Judicial branch. The courts have the power to interpret the Constitution and to declare laws or executive actions unconstitutional. This power gives the courts the ability to strike down laws or actions that they determine violate the Constitution. By dividing power among the three branches of government and giving each branch some degree of oversight over the other, the system of checks and balances helps to prevent any one branch from becoming too powerful and to ensure that the government operates in accordance with the principles of the Constitution. While the country USA was still stumbling upon founding itself as a nation, there were many disagreements over how the government should be structured and what its responsibilities should be. Moreover, there were tensions between the federal government and the individual states, since many were feeling that the federal government was trespassing on the rights of the states. The Bill of Rights, which was eventually added to the Constitution in 1791, places limits on the federal government's power in order to protect individual liberties and freedoms. The controversy over federal power and states' rights has been a central issue in American politics since the start. At its core, this debate centers around the balance of power between the federal government and the individual states. Advocates of federal power argue that a strong central government is necessary to ensure the unity, security, and prosperity of the nation as a whole. They rely heavily on the Constitution, which grants the federal government a range of powers, including the power to regulate commerce, declare war, and raise an army. These powers were outlined in Article 1, Section 8 of the Constitution, and include the power to collect taxes and regulate commerce with foreign nations and among the states, the power to establish a national currency and regulate its value, the power to declare war and raise and support armies and navies, the power to establish post offices and post roads, the power to establish federal courts and define their jurisdiction, the power to promote the progress of science and the useful arts by granting patents and copyrights, the power to make all laws necessary and proper for carrying out the enumerated powers. They also argue that the Supremacy Clause of the Constitution declares the federal law as the supreme law of the land, which means that the states must comply with federal laws and regulations. According to Article 6, Paragraph 2 of the U.S. Constitution, referred to as the Supremacy Clause, the federal Constitution and federal law generally take precedence over state laws and even state constitutions. Since the Constitution has been clear about the federal government's role, one might wonder about the reason of this whole controversy. The answer is the 10th Amendment. The 10th Amendment states that any powers not delegated to the federal government by the Constitution, nor prohibited by it to the states, are reserved to the states or to the people. This amendment is often used in favor of states' rights. There are many individuals and groups who believe that a strong federal government was necessary to maintain order, promote economic growth, and protect the rights and freedoms of the American people, primarily the Federalists. The Federalists were a group of early American politicians who supported the ratification of the U.S. Constitution and the creation of a strong central government. They included Alexander Hamilton, James Madison, and John Jay. The Nationalists believed that a stronger central government was necessary to address the economic and political challenges facing the young nation. Prominent nationalists included Robert Morris and Gouverneur Morris. Supporters of the Constitution, they believed that the new government would be more effective than the weak Confederation established under the Articles of Confederation. And there is the military and business interests. They believed that a strong central government could provide greater security for the nation and promote economic growth. The controversy over federal power and states' rights has played out in a number of key moments in American history, including the Civil War and the Civil Rights Movement. In the lead up to the Civil War, Southern states argued that they had the right to secede from the Union and form their own governments, citing states' rights as a justification for their actions. During the Civil Rights Movement of the 1950s and the 1960s, some Southern states resisted federal efforts to end racial segregation and discrimination, again invoking states' rights as a justification for their actions.
States' rights. Guess which right in the Bill of Rights was the most popular when it was written in the 1789? Free speech? Freedom of religion? The right to remain silent? Nope, the most popular was states' rights. That sort of makes sense when you think about it. The new constitution increased the power of the federal government. So many states requested more specific protection under the new Bill of Rights too. That gave us the 10th Amendment, which says that the power not given to the federal government are reserved to the states or the people themselves. So what kind of powers are those? Historically, each state has been in charge of the health, education, and safety of its people. These are known as the police powers, but some states deny the basic need of their citizens through racial segregation in places like schools. And in 1954, the Supreme Court ruled that such practice could no longer continue under the 14th Amendment. Some advocates of states' rights opposed the court's decisions, and the federal government got involved to enforce the ruling and to protect people of color. Today, the states are still in charge of schools, healthcare, and public safety, but they also rely on federal funds to help meet their needs. Often, these funds come with other conditions which can create issues under the 10th Amendment. The 11th Amendment also guards citizens of other states, the principle known as sovereign immunity. The government, both national and state, cannot be sued without its consent. Some tension between the state and the federal government is hardwired into the Constitution. While the federal government has certain enumerated powers, the Constitution also reserved many powers for the states. This includes the power to regulate intrastate commerce, conduct elections, and establish criminal justice systems. Some argue that states should have even more power to govern themselves, particularly in areas such as education and healthcare. However, others worry that giving too much power to the state could lead to a patchwork of inconsistent policies across the country. Questions you may ask. What is Bill of Rights from USA? The Bill of Rights is the first 10th Amendment to the Constitution. It spells out Americans' rights in relation to their government. It guarantees civil rights and liberties to the individual like freedom of speech, press, and religion. What is an amendment? An amendment is a form of official change made to a law, contract, constitution, or other legal documents. It is based on the verb to amend, which means to change for better. Amendment can add, remove, or update part of these agreements. What is called amendment? An amendment is a change or addition to the term of a contract, law, government, regulatory filing, or other documents. What does right of the states mean? States' rights guaranteed to the states under the principle of federalism. Under the Constitution, states have considerable autonomy to pass, enforce, and interrupt their own laws and to pursue their own public policy programs.
What are civil liberties? What are some key of civil liberties? And how civil liberties differ from civil rights? So, what we can say about civil liberties? Civil liberties are basically the rights and freedoms that citizens enjoy in a democracy. These liberties are designed to safeguard individual autonomy and protect individuals from undue government interference. They are protected by various legal documents, such as constitutions, bills of rights, and human rights conventions. They include a wide range of rights, such as freedom of speech, freedom of religion, the right to privacy, freedom of assembly, freedom of the press, and the right to due process. So let's mention some key of civil liberties to get it more. Freedom of religion. It concerns the right to practice any religion or no religion at all and to be free from religious discrimination. Freedom of speech. The right to express opinions and ideas without censorship or interference from the government. Right to privacy. This includes protection of personal information, communications, and the right to make decisions. Freedom of the press. The right to freedom of expression for journalists and media organizations, which allows them to report news. How civil liberties differ from civil rights. When we hear these two terms, the similarity of meaning takes root in our minds, but it's not the case. Although these two terms are often used interchangeably, scholars generally agree that civil liberties are those liberties that protect people from the government, those that guarantee the safety of people, their opinions, and their property from the government, as listed in the Constitution. The term civil rights, on the other hand, are not in the Bill of Rights. They deal with legal protection. It's generally used to refer to acts of government that make constitutional guarantees real for all people, ensuring that they receive equal treatment under the law.